Let me open this up and go straight across to Sanjay Hegde, Senior Advocate, and of course, J. Sai Deepak. Let me first bring you in, Mr. Hegde. Where do you stand on this issue? Are you with the petitioners, or do you believe that this should not be relooked?
Well, I'm not with the petitioners, certainly. But if any relooking needs to be done, it has to be done at the level of Parliament. Why do you want courts to do their dirty job? Parliament passed the act. In case Parliament wants to change its mind, let it do so. Why you ask? See, the act is in the 90s. Over 30 years have gone. You want to change your mind? Let Parliament do it. Courts shouldn't get into it.
Okay, courts should not get into it. J. Sai Deepak, why are we in the courts then?
See, the thing is, first of all, I represent one of the interveners, which is the Kashi royal family, which is in charge of the religious aspect of the Kashi Vishwanath, which has sought the return of the occupied structure known as the Razia Mosque, as well as the Daurara Mosque, where the Vindhamada temple previously stood. And we have also asked for the return of the Kapalishwar temple in Chennai, which was originally located where currently the St. Thomas Basilica is located. So we are representing direct claimants. Most of the parties, to the best of my knowledge, are people who have filed public interest litigation. There are no direct claimants in the picture. Now, the first level of response to Sri Hegde's position is that the longevity of a particular provision is no reason to deny its re-examination from a constitutional perspective, because that's exactly how we looked at Section 377 on the question of rights of homosexuals and LGBTQs and their rights to be treated with dignity. Okay. And today, when we are also looking at challenges to Section 124A of the IPC from the perspective of examining whether sedition as it stands today is constitutionally valid or not, all these provisions are older than the Act of 1991. So I don't think that is a legal or a tenable constitutional argument. I'm sure it may have some kind of persuasive value from Mr. Hegde's perspective, but it is not a constitutional argument. Two, I think the meeting ground where I think I would agree with Mr. Hegde is that the government certainly has the power to repeal the legislation. And therefore, the right of the government to repeal the legislation is something that we are certainly pushing for, and we are happy to actually advocate that particular position as well. But that is not mutually destructive to our right to challenge the validity of the legislation itself on constitutional grounds before the Supreme Court. So nothing stops the government from actually making its mind clear and also making it public. And that's exactly why its opinion is required. Its response to this particular petition is required. So the party in power today was in opposition at the time of the 1991 legislation being enacted and had vociferously challenged it on procedural aspects as well as on substantive aspects during the one day that it was substantively debated, which was 10th of September 1991. So perhaps now that you're in power, you can walk the talk, and the opposition to the legislation that you expressed can convert to repealment if you're so serious about it. Just to also add my points with respect to what Dr. Swami said, please note that I don't think it's possible for any one particular party to make concession or offer a concession on behalf of any other party with respect to any other place of worship, because it's ultimately a title property dispute. Okay, it's like me saying that I have the right to arrogate the power to concede on behalf of Rahul Shivshankar with respect to encroachment of his property. That can't happen, right? So all these negotiations or any of these so-called representative discussions, frankly, do not have any force of law. They don't bind any of the parties. So any organization may have said anything, but that does not take away the right of individual parties, which is why the legislation is such that you can't say, let's make an exception for Kashi or Mathura alone. How is that going to be possible? It's not possible for the Supreme Court to read an exception into a statutory provision if the legislature has not intended so. Only Ram Janmabhoomi was effectively carved out as an exception. It's not possible for the Supreme Court to say, in light of the so-called samvad that has happened between communities, let's read the exceptions to Kashi and Mathura in the provision. That's not possible. In fact, the exception to Ram Janmabhoomi itself points to the discriminatory and the arbitrary nature of the legislation, because we are saying, on what basis did the legislature arrive at the conclusion that there is no other pending or outstanding dispute?
Okay, so will that not open a Pandora's box and create a huge amount of upheaval in society?
Now, the very same apprehension was aired with respect to Ram Janmabhoomi, right? Now, nothing of the sort has happened. And all over the world, including United Nations, let's say resolutions, which you have placed on record before the Supreme Court, clearly speak of return of cultural property and heritage property of communities which have been affected as a consequence of colonization. And even in countries where there are settler colonial populations, so to speak, in the United States and Canada, there are rights of indigenous communities that continue to be respected. So here, the argument being made is that the WAQF has enough property to relocate its mosques, but as far as our places of worship are concerned, it is clear that a place of congregation is different from a place of worship, and therefore, once a deity is consecrated, it cannot be removed, and therefore we need those places back.
Well,
now, that argument, I'm sorry to say, is as constitutional as it gets. So there is no need for this apprehension that it could turn violent, it could open Pandora's box. Well, the Pandora's box has long been opened. It's not as if we have managed to find a way to close it.
Okay. Well, viewers, look, the Supreme Court is hearing the matter. We don't want to presage anything that's happening there. We should wait 2 weeks. The government has. Sir, I've run out of time, Mr. Hegre. Quickly tell me, you have a point?
Nothing new has happened today because notice had been issued on 12th of March 2021.
Right.
The Union of India has so far not put in any reply.
Okay, 2 weeks.
So I don't see why, what great thing has happened today.
Okay, anyhow, 2 weeks time. Okay, 2 weeks time, fair enough. 2 weeks time has been given. Let's see what the government has to say within the next 2 weeks. And from there on, viewers, we will have a greater idea of how this entire episode is going to unravel. I'll leave it at that. Thank you very much, gentlemen.